It's 10:44 a.m. This case was noticed for a 10 a.m. oral argument, and actually Miss Carroll, the counsel for the appellant, when we were setting the oral argument, she requested to appear in person, and we granted that request. And we have no word as to why she is not here. We've tried to find out if she is contacted, and I guess she's not contacted the clerk's office from what we hear so far, and they've made efforts to contact her with no response. So the third case is set for 11 o'clock, so I mean, it would seem as a matter of due process is broadly used in this scenario, but theoretically, if people want to watch the oral argument set for 11 and we started 15 minutes early, we may get complaints from the public at large for doing that. So, well, I guess we will proceed with the 10 o'clock. Do you want to stand up and argue anything about anything? And if we have maybe we have at least a question or two?
Sure, if I may.
Sure. I mean, if Miss Carroll comes through the door and we'll start over, we won't hold this against you.
Okay.
Or we won't deduct. That's a bad phrase. We won't deduct the time from that. We'll give you the 20 minutes again. So.
Okay. Good morning. I'm Elizabeth Harris. I'm glad that you asked me because I do want to make a correction, or at a minimum, a clarification from my brief.
Okay.
With respect to the contempt finding, this court has granted Ms. Carroll's request for judicial notice of there were two prior appeals in this case. And it is not in our record in this case, but it's in the judicial notice records. There is you'll find it at 2154 of the first record on appeal. Those cases were consolidated. One record was submitted to the court. You'll see a November 2019 order granting temporary attorney's fees. So I don't mention that in my brief. As a matter of fact, to be completely transparent, I think I was confused on this, and I caught this last night. So that was granted. That is the basis for the contempt finding. And I want to take a minute and explain that a little bit further. So at that time, the court says you need to pay $900 a month. That is the order that's abated. But if you take a careful look at the timing of that, at the time it's abated, it should have all been paid. And it had not been paid. As a matter of fact, the testimony is that I believe it was 20,000 and change should have been paid, 11,000 was what was paid. So at the time that the motion for contempt is filed, there is an outstanding amount on the temporary fees, and that is the basis for the court's finding of contempt.
Let me ask you about the income deduction orders for the attorney fees. The initial brief suggests that under 61.1301(1)A, that IDOs are to be used only to establish and for the payment for alimony or child support that's either been modified, enforced, or established. There is an IDO, I think, for one of those, but there's IDOs just for the attorney fee awards. I don't want to overread your brief, or you correct me if I'm wrong. Did you, in essence, say, well, if we agree with that argument of the appellant, then case law suggests that we can simply vacate and remand it for the trial court to consider what amount of attorney fees were related to the enforcement, establishment, or modification of child support and alimony, and to then issue an income deduction order related to that?
That's exactly right. And my basis for that would be the Diaz case that's cited in the briefs, as well as I think, the language of the statute itself seems to say it authorizes...
Subsection 1B kind of...
I'm sorry.
Yeah, subsection 1B kind of talks about attorney fees and costs regarding the support.
Yeah, collecting and securing, and I would suggest that securing would certainly entail fees that were in the course of the trial, and frankly on appeal, because in the first in the first appeals before this case was the issue of alimony. So certainly it would, the securing of the alimony would encompass,
Well, you'd agree that
encompassed under the IDO.
well, I wouldn't say good, some of the attorney fees, and I guess it's relative whether it's a good portion of it, a good bit of the litigation dealt with the marital home and the efforts to sell it.
That's right.
And that, so those would likely, well, we would leave it to the trial judge to make that determination. But I mean, there's at least record support to say not all fees were engendered simply for the purpose of enforcement, modification, or what's the other, establishment of alimony and/or child support.
I think there's certainly room for that argument. I would just throw out this kind of, to mix that up a little bit, some of, so much of alimony is dependent on what the distribution of the assets are. And in this instance, we have an order to sell and do an equalizing payment, and all that's factored in. So I would say there's room for further argument as to whether the marital home caused a
Yeah, I mean,
passed down or a trickle down onto the issued alimony. So there's certainly room to argue how much of that is, but I don't dispute the basic premise.
no, I mean, I get, we obviously have the text of the statute drives what we do or what we are required to do, and that's certainly, supremacy of the text. We're very familiar with that. And so the statute says what it says, so we pronounce whatever our rulings are. Trial judge gets and says, scratches his or her head going, well, how do I do that? And we say, well, figure it out and do the best you can, kind of thing. I'm saying that somewhat tongue-in-cheek, but I mean, it is sort of like, well, was this 20 minutes for the attorney, for the alimony, or was this 20 minutes of attorney fee time for?
Well, and I think that becomes, I can speak directly. I wrote the brief in that case, and it becomes really difficult sometimes to parse out those things. But I think that the courts have already told us that that's what we do in circumstances where there may be a direct sanction, right, for like.
I get it. I'm just saying, being a former trial judge, I was we pronounce on high, interpreting what the legislature plain language of statute says, and then, we sometimes kind of forget that then there's the real world scenario. Well, how do I do this now that you guys in Daytona have said this?
And certainly the trial, when you're litigating the trial, that all of this is coming in. So how many minutes of every trial day was devoted to
singing to the choir? I get it, but that's we play the cards that are dealt to us, right? Okay.
Other than thanking you for the opportunity to correct that, because I was not correct in my brief, and referencing you to 2154 of the record that you took judicial notice of. You'll see that order in there. And thank you so much. I appreciate the opportunity.
All right. Thank you, counsel.